So once again, welcome back to the channel. My name's Conor Johnstone. I'm a specialist motor and defence solicitor with M.A.J. Law. The purpose of this video is to talk more about the MGDDB procedure in drug driving cases. Now, if you've done any reading or research online, if you're under investigation for drug driving, if you've been charged with the offence of drug driving, then it won't take long until you come across this document, this booklet known as the MGDDB booklet, and it's really important in any drug driving case that you take an opportunity to look at this document, to review it, hopefully with the help and the assistance of a solicitor, because it can be really complicated, and I'll show you why, and we'll go through a copy of this document in just a moment. But the reason it's always worthwhile checking if this booklet was completed with you in the blood test room at the right time is because if it wasn't, it doesn't matter if you're over the legal limit for any drug and you are charged with drug driving, you cannot be convicted if the information within this document is not given to you. So we're going to spend a little bit of time going through this booklet. I'll point out, I'll be able to show you how complicated this document can be. Even for somebody like me who's been challenging drug driving cases for a long time, it took me a while to get my head around the ins and outs of the MGDDB procedure. So for any untrained police officer, a police officer that's newly qualified, a police officer that's less experienced in dealing with these kind of investigations, then it can be a real minefield, and that can give us an opportunity, give us a way of avoiding a conviction in a drug driving case. So again, always worthwhile checking. But let's get stuck into it then. I've got a copy of an MGDDB booklet with me. Now, this document looks a little bit smaller than what you might expect to see at a police station because I've printed it double-sided. They aren't always printed at the police station double-sided. Now, the purpose of an MGDDB document is to guide the police officer through the procedure when taking an evidential sample of blood from somebody at the police station. And the reason it's so important, it plays such a critical role in obtaining an evidential sample, is because it's not as simple as just giving your consent to providing a sample of blood. And lots of people perhaps wrongly assume that if I agreed to give my sample of blood at the police station and I'm then shown to be over the legal limit, that must then mean that I'm guilty of the offence. I can't challenge the case and I've got to go to court and plead guilty. You might even have indicated a guilty plea at the police station if the police asked that question, which, by the way, doesn't matter. You're still perfectly entitled to challenge the allegation, go to court and enter a not guilty plea. And this actually is one way that you can do that, particularly if we're concerned that this document wasn't completed correctly. And at certain points and at certain parts of this video, I will put up a clearer copy of the MGDDB document so you can see that. I'll also include in the description of this video a link to a copy of the MGDDB document so you can take a look at that yourself as well, and perhaps think back whether you remember those questions being asked or whether you recall this document being completed. Now, the MGDDB document is the second document that has to be completed by a police officer in the blood test room. It's not the first document the officer has to complete when asking a person to provide a sample of blood. Now, yes, it is one of the most important documents, but that's not how he begins the procedure. Interestingly enough, and unusually enough, when a police officer is asking a person to provide a sample of blood for drug driving purposes, he actually has to begin the procedure with an MGDDA document, which you typically find in drink driving cases. There are certain parts of that document that's relevant and applicable to drug driving. So the first few pages that the officer has to complete in the MGDDA document is more general and generic questions, which he has to ask even though this is drug driving. MGDDA typically deals with drink driving offences, but curiously enough, the officer still has to go through part of the MGDDA document with you. So in fact, it's not one booklet you should see being completed by a police officer in the blood test room, it's actually two booklets. So again, think back. Do you remember the police going through two separate individual 20, 25 page booklets with you in that blood test room? It's not just the one, it's those two booklets. If the officer hasn't done that, if you skip certain parts of the procedure, then again, that may prevent the prosecution from relying on the blood sample, because where the procedure is not correct, then generally the blood sample is considered inadmissible and therefore it can't be used in evidence against you. Now, the MGDDB document that I have in front of me is a standard MGDDB document. It's the latest version, and it's the version that the officer should have gone through with you at the police station. But let me give you some idea as to how complicated this procedure can be. I'll run through certain parts of the MGDDB document that may or may not jog your memory, and hopefully it'll better enable you to think back and work out whether this document was filled out with you in the blood test room. So let's get stuck into it then. So the first part of the MGDDB document looks a little bit like that, and I'll put a copy on the screen so you can see that. And it's quite a complicated document. There's lots of different questions the officer has to ask you. There's various sections of the form that you have to fill out depending on the type of investigation that he's carrying out, whether it's a section 4, driver whilst unfit, whether it's section 5A, drug driving, whether it's both, whether it's blood, whether it's urine. So really quite complicated for the police to properly understand which parts of this form apply, which are applicable, and which parts of this document have to be filled out. And that again is where you see mistakes being made, a lot of confusion on the part of the police, often making mistakes, filling out the wrong sections, and as a result not giving you the right information that you have to be given under section 7 of the Road Traffic Act. Now, the first part of the MGDDB document relates to the offence that the officer is investigating you for. And we'll go through this booklet as if the officer is investigating you for a standard drug driving offence under section 5A1A of the Road Traffic Act. Now, you can quickly work out whether your case is a standard drug driving offence because you would have been swab tested at the roadside, either for cannabis or cocaine, arrested for exceeding the prescribed limit for some drug, off to the police station where the police officer is then asking you to provide a sample of blood to check if you're over the legal limit. And remember, in a standard so-called ordinary drug driving case, impairment doesn't really come into it. It's whether you're over the legal limit or under. If you're under, typically you're not charged. If you're over, then you are prosecuted for the offence of drug driving. It works similar to drink driving cases in that respect. So the first part of the MGDDB document, I've highlighted the section that the officer would have to complete there, and that's section B14 on the MGDDB, and that relates to excess specified drugs, which again is drug driving. And just very quickly, you can see there at the bottom, so over half of that document that the officer has to complete contains a lot of different guidance notes that the officer should work through. And again, this is what takes up a lot of time when going through this document, is the officer has to make sure that he refers to the guidance, that he's giving you the right information, and that he's filling out the right sections of the form. So immediately, it asks the police officer to jump straight to section 14 of the MGDDB document. So you would think that he would work through it in chronological order from 1 all the way through, 2, 3, 4, 5, so on, so forth. But straight away, he's got to go to B14. So let's jump to B14 in the MGDDB document, and I'll tell you what B14 relates to. So B14 in the MGDDB, again, it contains further guidance notes on the MGDDB document at B14 in relation to how the evidential specimen is taken, and not to confuse the procedure with unfit cases. So if it's unfit through drugs, then it's a slightly different process. If it's over the legal limit, which is what we'll go through this as a section 5A offence, then the procedure that's involved in that and how the officer has to go through that form. So he would explain to you that you're being investigated for an offence under section 5A, and as a result they want to take a sample of blood from you. So he highlights offences to be investigated, excess specified drugs only, section 5A of the Road Traffic Act, and then immediately go to B15. Now B15 relates to the medical defence, and so the police have to rule out the possibility that you are prescribed any one of the drugs that the police will analyse that blood sample for, because remember, they'll test your blood sample not just for cannabis or cocaine, not just for the drug that you failed the swab test for, they will test that blood sample for all commonly abused substances, and that includes both controlled drugs, so illegal drugs, but also prescription drugs as well. Now, if on the off chance the results come back and you have a prescription drug in your system, so let's say, for example, diazepam, the legal limit is 550 micrograms per litre. Diazepam can legally in this country be prescribed, although it's not all that common. But if the results come back and you're over the legal limit for diazepam, but you've raised this with the police officer, you've told the police, in the MGDDB document, when asked that question, that you're prescribed diazepam, then they can take that into account when making a decision as to whether or not to charge you, prosecute you for the offence. Now, clearly, if you're taking the drug as prescribed by a medical practitioner, then it wouldn't be appropriate, it probably wouldn't be in the public interest to prosecute you for drug driving if you're taking the drug you're prescribed for medical reasons. So the first part that the officer would go through is B15, the medical defence, where he'd ask you if you are taking or using any drugs or medication prescribed or supplied to you for medical or dental purposes. So think back whether you remember the officer asking that question. It's a closed question. It's either yes or no. If you are taking drugs that are prescribed and you explain to the officer that you are, then he may ask you what it is that you're taking, the amount that you're taking, whether you've got a prescription for that drug, and he's going to know all that information down on the section of the MGDDB document that he's just been through. Next, we move on to the preliminary test. And one of the problems with this document, and why it's so poorly designed in my view, and therefore so complicated to complete by police officers, is that you're having to jump back and forth and back and forth. So we've already started the drug driving procedure and the process of taking blood. The officer has already asked you the medical question and told you that you're being investigated for the offence of drug driving. But now at this section in the form, at B16, we're going back to what happened at the roadside. And the officer then has to complete information in relation to what went on at the roadside, whether there was a swab test administered or alternatively a field impairment test, and what the results of either of those tests were. And the reason the officer has to do this is because by law the police cannot just jump straight to an evidential sample of blood. There has to be some form of preliminary test carried out before he has the power to take a sample of blood under Section 7 of the Road Traffic Act. Preliminary tests are covered by Section 6 of the Road Traffic Act, and that would be at the roadside one of two things: a swab test or a field impairment test. Now again, either of those things can technically happen at the police station, but that would be unusual. The most common form of preliminary test carried out at the police station is an examination by the nurse. So if there was no swab test in your case and no field impairment test, a field impairment test might be stand on one leg, walk in a straight line, count to 30, etc. If that hasn't happened in your case, then the police can't take blood from you unless you're examined professionally by a medical practitioner in the blood test room at the police station, who will check things like your pupil size, your blood pressure, may ask you certain questions, your general demeanour as well. And if he or she forms the opinion that you are under the influence of some drug, then they will notify the police officer of that, and that then gives the police officer the grounds to go on and continue with the evidential blood taking procedure. So a B16 in the MGDDB document, preliminary drug test or medical examination, and it would be normal for the officer to circle B16A if preliminary drug test already administered with a positive result, and that would be the roadside swab test. We then jump from B16 to B20 in the MGDDB document. So you might remember the officer sort of flicking through various pages of this document as he asks these questions and ticks all the right boxes. It's then on the officer to try and identify the kind of offence that you're being prosecuted for. And unlike with drink driving offences where there's really only a single offence that you could be prosecuted for, driving whilst over the prescribed limit under Section 5(1)(a) of the Road Traffic Act, with drug driving offences, there's at least 3 offences that you could be charged with. Section 5(a), drug driving, the most common. Section 4(1), driving whilst unfit, less common, but you still see that offence being charged. Or it could be both of those offences. And technically the police are entitled to prosecute you for both of those offences if it is appropriate to do so, depending on the type of drug they suspect that you might have been consumed. So the officer can circle the appropriate section of the Act that he intends on investigating you for, and then depending on the type of offence that he's investigating, he then has to jump to either B21 in the form or B22 from B20. So we turn over the page, and this is a really important part of the MGDDB document, if not the most important part of the MGDDB procedure in general. And this is where the officer has to explain to you that he's requiring you to provide a specimen of blood for laboratory analysis. But the most important part of this entire section, B21, is where the officer explains to you that you don't have to give a sample if you don't want to. Remember that to some extent the procedure is optional. Nobody can forcibly take a sample of blood from you, and that's because a sample of blood is known as an intimate sample. So unlike if you give a swab sample for DNA or fingerprints, those are what are known as non-intimate samples, and so a fingerprint can be taken by force and a DNA swab could be taken by force. But an intimate sample like blood cannot be taken by force. Now, we're not talking about consent. Consent we come to at a later stage in the MGDDB procedure. This section of the form at B21 has to be read out word for word. It has to be correct. You have to be told in no uncertain terms by the police officer that's requiring you to provide the sample of blood at the police station that you don't have to. And if you don't give a sample of blood, what the consequences or the outcome might be. And this is very similar, in fact, in drink driving cases. That too, whether it's breath, blood or urine, to some extent is optional. You don't have to provide that sample. There may be consequences, but they have to be explained and it has to be described in a certain way. Now, it may be that the officer hasn't got this document with him. It may be that a police officer hasn't been trained on how to conduct these procedures. Drug driving offences are quite new in comparison to lots of motoring offences or general criminal offences the police will deal with day to day, so perhaps they're less familiar with the procedure, and perhaps the officer's rushing because he wants to get the sample of blood from you as quickly as he can because he wants to get the highest reading. Now, you don't need to be a forensic toxicologist to know that drug levels will drop over time. So the longer it takes the police officer to go through all these procedures and this paperwork, answer questions, tick boxes, note down your responses, the more likely it is that the level of any drug in your system is reducing, is dropping. And the biggest risk for a police officer is that he takes too long going through the process. They go on and take a sample of blood from you, it's tested, and you're under the legal limit. So things can happen quite quickly in police custody. So again, think back whether you remember a police officer going through these two separate 20, 30-page documents in the blood test room and whether any of these questions were asked and whether any of this information was given to you. Because again, if it wasn't, then the police have directly breached there Section 7 and various other sections, in fact, of the Road Traffic Act as well. And as a result, they can't use the blood sample in evidence against you. We take the blood sample out of the equation. As a result of that, you cannot be convicted of drug driving. And again, that's why the MGDDB procedure is one of the first aspects of a drug driving case that I'd like to check, because it's one of the easiest ways of avoiding a conviction and remains one of the most common ways that we avoid convictions in drug driving cases. So they have to explain this to you. You have to give that sample and what the outcome might be. If that's not correctly completed, when I receive the MGDDB document in your case, if it's not completed at all, then I would immediately invite the prosecution to withdraw the case against you, and they should know that if that section of the form is not completed correctly, then they have no case to answer. They should be offering no evidence or perhaps withdrawing the charges before the case even goes to court. And a final point, MGDDB documents can sometimes be obtained prior to first court dates as well, so don't think you have to wait until a first court hearing to get that. A lot of the initial and preliminary evidence that I obtain in drug driving cases weeks before first court hearings, in fact, sometimes even earlier, will usually contain a copy of the MGDDB document. So I'm able to check these issues before the case even goes to court. Now, once the officer has given you that information and providing you agree to provide a specimen, we then go from B21, and this is where it goes full circle, back to the beginning of the document at B7. So we then jump back to B7, and this is where we then deal with consent. So the officer has required you to provide a sample of blood. He's explained your options. He's told you what would happen if you didn't give a sample. He's dealt with the issue surrounding the roadside test, any preliminary test as well. Perhaps there has been an examination from the nurse in police custody. And now we're moving on to the point where consent, and by this point we could be half an hour into the MGDDB procedure, we might be 40 minutes or so into this document. So try and think back to how long you might have spent in the blood test room and whether you spent upwards of 40, 50, 60 minutes going through this document. Now again, as I've mentioned in past videos, consent is the easy part, because whenever a sample of blood is taken, for whatever reason, whether it's at a GP, whether it's at the hospital, whether it's at the police station, everyone knows that you have to give consent to provide a sample of blood. So I would usually expect the police to know that. And this section of the form at B7 that deals with consent, it is usually always okay and is filled out correctly. We'll come on in a moment to other sections of the form that come later, which may not be correctly completed. But the officer has to ask you for your consent to give blood. And the most important part of this document at B7 is that you have to provide consent in the presence of the medical practitioner. So it's no good going into a room with a police officer before the nurse even turns up and giving your consent to give a sample of blood. That has to be in the presence of the medical practitioner or when you give consent, because of course the medical practitioner has to be confident that you have given your consent, otherwise he or she cannot take a sample of blood from you at the police station without your consent. Now once you've given consent, they then skip to B10, so again various pages that we skip when we're investigating a drug driving offence, and this is where they actually take the sample of blood. So this is the point, the procedure, when they'll obtain the evidential sample of blood, providing you've given your consent and you've answered all the questions appropriately and as you should have done leading up to this point. This part, the document is important when we look at timing, is the time in which the sample was taken from you. So again, I'll put a copy of this section of the document on the screen so you can see that, but blood specimens taken, there's some guidance there in the grey box that you can see that the officer should go through and read and refer to those notes if there's any confusion on his part, and you'll then see specimen provided at, time, on, date. Part of the specimen offered to the subject. Now, remember that under section 15, subsection 5 of the Road Traffic Offenders Act, you must be offered your part of the blood sample. So once you provide a sample of blood, it's not then just taken away by the police and sent off for testing. It has to be divided, split by the medical practitioner into two separate vials. You can't take two separate and distinct samples of blood from you. It has to be one sample that's divided into two. So if you think the needle entered your arm more than once, or if you think the nurse has used one of these specialist needles where they've taken one sample, they've kept the needle in your arm, you've taken out the vial, connected a second vial, and then taken a second sample, that too would normally constitute two separate samples, which would be unlawful as far as the procedure is concerned. So you must then be offered your part of the sample. If you've declined that, then please get in touch, because there's a few things that we need to sort out quite quickly. If you have declined your part of the sample, we'd normally want you to try and get hold of that for various reasons that we won't discuss in this video. The sample is then sealed in your presence. It says specimen sealed in the presence of the subject, again at time, on, date, by either the nurse or in this case the officer sealing, having ensured that both parts of the specimen have been shaken by, that's normally the nurse, so Nurse Smith, for the required time, and then part of the specimen accepted by the subject, either yes or no, to circle the appropriate answer at time, on, date. The reason the specimen has to be shaken for a certain amount of time is because the vials that are contained within the police-issued blood kits are already coated with a sodium fluoride preservative and an anticoagulant. Now, you may not notice from looking at the vial that it contains those solutions because it's a clear solution, and the warmth of the blood will melt the preservative and the anticoagulant. It enters the blood, and that means that the sample remains viable for testing for a long time. Now, I may want to make sure that it was a blood testing kit that was used. I've had cases in the past where urine vials have been used instead because blood testing kits weren't available, and urine vials wouldn't contain the right preservative or anticoagulant because it's not blood and urine doesn't coagulate. So if it was a urine kit that was used or a urine vial, again, that's going to lead to the case against you failing. Now, once you've provided those specimens, we go from B10 off to B12, where we then deal with specimen continuity. Specimen continuity is critically important in drug driving cases because the most valuable evidence for the police in this case is the sample that you provided. They want to be as certain as they can and make sure that they can use that blood sample in evidence against you. Now, with any exhibit, And more importantly, with evidential blood samples or urine samples, they have to be able to establish the chain of custody. In other words, every hand through which that sample has passed from the moment that it was taken to the moment that it was analysed. There should be a log. It has to be traceable. There should be serial numbers, names, details on that vial. Is it labelled in the right way? Is it stored in the correct packaging? How long is it then stored in the fridge? Is there a log? Is that fridge temperature controlled? When it's sent to the lab, well, who transports it? What courier? What was his or her name? Is there a record of that? When it was received by the lab, who received it? Who signed for it? Who opened it? And eventually, who analysed it? And this is the chain of custody. Now, if any part of that chain of custody is broken, if the sample is unaccounted for a certain amount of time, even if only an hour, if that chain of custody is broken, then the prosecution may not be able to rely on the blood sample as an exhibit, in which case you couldn't be convicted because without the blood sample, they can't prove that you were over the legal limit. So chain of custody and continuity, really important. Always check B13 on the MGDDB. This is often a section of the form that's left blank because the officer may not get around to completing this section of the form, and that may be because he's taken the sample of blood, you've been offered your part of the sample, he's filled out the rest of the MGDDB, and he just doesn't bother with continuity because he's left the room by that point. He's happy, he's got your blood sample, you go off and you do your DNA swab, your fingerprints, so you're thrown in the cell, or you might be released at that stage. Now, once B13 has been completed, the officer then concludes the procedure, and you can then be either released, interviewed, DNA, biometrics, swab test, or you might be placed in a cell. The only reason you would normally ever be placed in a cell having given a sample of blood is if there's evidence of impairment and that evidence is ongoing, and the police wouldn't normally be comfortable releasing you from police custody if they suspect that you're still under the influence of some drug, because the risk is that you might leave the police station, get into a vehicle, and then harm yourself, somebody else, or commit further offences. Although, to be completely honest, in most drug driving cases, there is no evidence of impairment, and you may know by now, having done your own reading and research, that the legal limit for most drugs is zero tolerance. So it's not always about impairment in drug driving cases. You may be completely sober, fit and well enough to drive, control a motor vehicle, but if you're over the legal limit, even if you're not impaired, then they can still prosecute you for the offence of drug driving. And again, that's why it comes back to the idea that that blood sample is critically important for the prosecution, if not the most important piece of evidence that they have against you. So if I can use the MGDDB procedure, which may not have been completed correctly or filled out in the right way at the right time by the police officer, if we can get rid of the blood sample even at the early stages or perhaps at the later stages, then the case against you would collapse and you wouldn't be convicted. As a final point, again, not something we're going to cover in this video, but the way the sample was analysed. I touched upon it briefly earlier, but we'd always want to check as well the way the sample was stored, analysed, tested, what lab, what qualifications might that forensic worker have had, how much experience as well, because of course that's all going to play a part in the reliability of the results that the prosecution want to use in evidence against you. Now, if you have been charged or suspected of drug driving, if you think the MGDDB procedure wasn't carried out correctly, perhaps you think that there might be other defence arguments that apply in your case, maybe something just doesn't sit right with you in how you were dealt with or treated by the police when you were arrested and taken into police custody. As always, we do offer free initial advice to anyone that's in a situation where you've been charged or suspected of drug driving, whether it's you, a friend or a family member. I'm always happy to speak to anyone that wants free initial advice. You'll find a link to our website in the description of this video, our contact details as well. I or any other member of my team will be more than happy to speak with you if you want that free initial advice. And again, you'll find those contact details in the description of this video. So thanks again for watching this video. Hopefully you found it useful. Hopefully you found it informative. There's more videos coming as we dive into the different ways that we can challenge and defend motoring cases, in particular drink and drug driving offences. Feel free to comment and subscribe. We appreciate all the support that we get, and there's more videos coming, and I'll see you in the next one. Thank you.